Now, we've just gone past 6:30, and now it's time to look at some employment law questions that you have been sending in over the last few weeks. Thank you very much for those. And what we're going to do is we're going to speak to Jacqui Dempster, who's an employment lawyer, and she joins us in the studio just now. So, Jacqui, welcome to the Friday Night Lounge.
Good evening. Thank you very much, Matthew. Pleasure to be here.
And first of all, before we kind of get started, tell us a bit about Jacqui.
Well, I'm a lecturer at the moment at Stevenson College in Edinburgh. I lecture in law there, and I'm also a lecturer for the Open University in Scotland. Prior to that, I was a solicitor, and I specialised in litigation, and then specialised in particularly employment law litigation later on.
And so basically, just tell us about the range of services that you provide as a lawyer in terms of certain cases that may come up.
Well, I don't actually practice as a lawyer these days. I purely do lecturing now, but my experience is giving advice, consultation, leading people through the process of employment law, and taking them to the tribunal if they need to go to the tribunal, and giving them the advocacy.
Right. So I think now we know a wee bit about you and your background and experience. You're obviously very, very experienced. Let's get stuck into the questions, why don't we? So
okay.
Now the first question comes from a listener who wishes to remain anonymous. Basically, the question is, what qualifies as unfair dismissal within law? Now, the listener who sent this in reckons that it's usually a written warning before you get the dismissal. Is that correct?
It's a little bit more complex than that, unfortunately. You have to show, first of all, that you qualify to claim unfair dismissal.
Okay.
And it's a statutory protection which doesn't come into effect until you've been with the employer now for 2 years.
All right.
So you can't actually claim it. It was 1 year prior to the 6th of April this year, but now you have to have 2 years continuous service. You have to be an employee and not a self-employed person.
Right.
And you have to show that there has been an effective dismissal to qualify for it. Now, that's the general situation. There are some exceptions to that. You could be unfairly dismissed for special reasons, which are automatic unfair dismissal. But nevertheless, mostly you have to have that 2 year period. Sorry.
What? No, of course not. Why was it changed from 1 year to 2 years? Do you know?
I think probably because the pressure on the employment tribunals were becoming so heavy. There were 218,000 in the period 2011-2012. So I think that there are so many claims going ahead now that perhaps it was felt that we had to take some action to reduce that. Now,
I know it's a wide-ranging question, and I know you can't really talk about specific cases and that kind of thing, but why do you think the unfair dismissal rates are so high?
In terms of the compensation?
In terms of the compensation, pretty much in general, really.
Well, there is so much employment law now. It's very complex for employers. It's a real problem. They can't keep up with it, really, and they find themselves on the wrong side of the law. So that's why there are so many tribunals. Employees are finding that their rights have been infringed, and employers are a rather unwitting bunch in a lot of cases, and do make mistakes, and that's why it leads to an employment tribunal.
Now, when it comes to unfair dismissal, if you find out that you are in the grounds of being unfairly dismissed, how would you go about trying to resolve that? Okay, well, you can.
There are a number of potentially fair reasons to dismiss, and they're listed in the Act. That's capability and qualifications. So if you're incapable of doing the job, or you don't have the qualifications, that's one ground you could be dismissed. Conduct, misconduct, doing something wrong, retirement, redundancy, and contravention of statute. You're not allowed to work because of some legal reason, or some other substantial reason. They're the grounds for potentially fair dismissals. Now, the employer has to show that he has a potentially fair reason to dismiss you in the first instance. Once he's done that, he then has to act reasonably in dismissing you for that reason. And that means that he has to go through a fair procedure to do that. And that generally means a process of investigation, first of all. He can't just say, right, you're out the door.
Right.
He's got to have this period of investigation. So he takes witness statements, gets the any documentary evidence that's necessary to show that he has reasonable grounds to dismiss you. He then has to have an informal meeting with you on the investigatory side, and then after that, if he feels that he has enough evidence, he then has to go ahead and invite you to a disciplinary hearing. Now, he has to do certain things. Before that, he has to give you written notice. He has to put certain things in the letter in that written notice, including the evidence against you, the fact that you may be dismissed for it, and tell you that you're allowed to have representation of either a work colleague or an accredited trade union representative with you. Now, if he doesn't do that, if he doesn't carry out the procedure,
right,
then he hasn't acted reasonably, because he cannot base a case where you haven't investigated, and the employer can go down at a tribunal simply because they haven't followed that requisite procedure.
Now, when you were outlining the procedure to us, it sounded I could see why the employers are maybe dread and cringe at the idea of going through that process. It's a long and unwieldy process, which
Absolutely.
for businesses, it's incredibly expensive to go through, even just to go and
Time and resources are limited. Knowledge of the employer is limited, and it's a really difficult thing for an employer to have to face, to go through all of that. But nevertheless, if you don't do that, if you were being taken to court for a criminal action, for example, you wouldn't want to be charged with something without having had the evidence,
yes,
put before you. And it's the same here. Jobs are so important to people these days. They're not easy to come by. It's a stigma against you if you've been sacked. And clearly, employees, on the other hand, want to be treated fairly and to have their side heard.
So on one half, it's incredibly complicated and somewhat expensive for businesses, but on the other half, it acts as a safety mechanism for the employees.
Absolutely. I mean, it works both ways. If the employer does it right, then he'll be fine. If the employee has the process there, then they're guarding against the possibility of dismissal and being out of work.
So hopefully we've answered your question there. So thank you very much for sending in that question, and that goes to our anonymous listener who sent that in. Now, the second question, this one's a much juicier and much more complicated one, I have to say. I mean, when I read the email, I couldn't believe the situation here. But right, what we'll do here is we'll read out the email that we got from the employer, who only wants to be known as Richard. He says there's a young lady who works in the office that he supervises. She has been employed for less than 6 months and has recently announced that she has several mental health issues. She did not disclose this on the medical questionnaire issued at the point of employment, and until recently there had been no issues, but a few weeks ago a colleague caught her self-harming in the toilet. And as a duty of care, he intervened, offered support, and suggested that she should contact her doctor, or indeed attend a clinic at the Queen Margaret Hospital, where she had apparently been treated previously. She has not taken any of this advice, and her behaviour has become erratic in the office, often upsetting other members of staff. Following an incident involving another member of staff a few weeks ago, who he also has a duty of care for, he sent her home and asked her to contact her GP. She then wrote a letter to Richard saying that I was discriminating against her, as he put it, on the grounds of her mental health and condition, and has since made threats about contacting a solicitor. Now, and he wants to ask the question, where does he stand on this one, Jacqui? And this looks to be a very, very, very tricky situation.
It's a very complex situation. My heart sank, as you know, when you mentioned this one to me. Now, it's probably one of the most difficult problems that an employer has to face, because it raises health issues. It also raises the spectre of disability discrimination.
Oh, yes.
Now, any discrimination claim which is successful can lead to unlimited compensation against
Right.
the employer. So it could be hundreds of thousands. It could put a business out of
business. Yes.
Out of business. Yeah.
So how would he go about doing this?
Okay, well, I've actually broken this one down because there's a few issues in this one that I think he needs to be aware of. Now, he said, first of all, that she's been employed for less than 6 months. We just talked about the continuous service period for unfair dismissal. There is no continuous period of service that needs to be established here. From the day of recruitment or pre-recruitment, a person can claim discrimination if they feel that they have been discriminated against, i.e. they've been turned down for a job because of one of what we call the protected characteristics under the Equality Act, disability being one of them. So, you know, you can be there a day, you can be there 2 days. If you're discriminated against, that's... You can raise a claim at that point. So that was the first issue that I wanted to raise for him. The next issue that he mentioned was that she didn't disclose on the medical questionnaire that she had an illness. Now, employers obviously feel it's pertinent to ask about health, and you know that's justifiable in a common sense perhaps view. But in actual fact, since the Equality Act 2010, Section 60 of that Act actually outlaws questioning about health.
All right.
So you're not allowed to ask about the health of a job applicant before the offer of employment.
Is there any reason for that? Is that to come in terms of equality, to stop discrimination?
It's to make sure that you don't rely on the fact that they have a health condition to refuse them employment.
Right.
So, you know, everybody deserves a level playing field. It doesn't mean because you're disabled or have an illness of some sort that you can't work. And that's the way that the law looks at it nowadays. So that's one of these, the new rulings, which probably not many people are aware of. So if any form that you see asking you about your health in general is not permitted, you might be allowed to ask about what reasonable adjustments that you might need if you were to be offered the job. But that's really about all you should ask. And of course it does, if you do ask the question, it puts you on notice that somebody does have a disability, and you have to be very careful about what you're doing thereafter. So, you know, it's a difficult problem. Then the employee, once taken in, has announced that she has some sort of mental health issue. So if the employer didn't know of it before, he's now been made aware of that. So now he has to ensure that a proper procedure is followed for the employee, and it's a dialogue that is to facilitate keeping the employee in work, not to dismiss them in any way. Yeah, because of that, because then you're falling into the realms of
discrimination.
Discrimination, yes. Yeah, that's right. So Richard has to exhaust every possibility, really, to keep this employee in post. And he has to go through a fairly lengthy medical process now to try and find out whether she actually has total lack of capability to do the job, or whether he can facilitate her with reasonable adjustments to stay in post and to carry out the job. So that was the next issue. He mentioned the duty of care. Absolutely, he's got a personal duty to employees, and he has to make sure that he's looking after everybody. I don't know what happened that day, what the incident was. If it was a dangerous one, then he was right to perhaps say, go home, let's diffuse the situation, maybe go and see your doctor, find out if you're fit to work. If you are fit to work, then come back in and we'll have a chat and see what we can do to help you, because you have to make sure that you're helping the employee and be seen to be helping the employee to stay in post. Otherwise, you know, if you don't look at what's wrong with the employee and you're putting extra stress on that employee as well, that's exacerbating the disability, then not only do you have possible unfair dismissal, discrimination, disability, you also have the possibility of a personal injury claim.
All right, I see. And
so it all adds up.
Yes, so it's a very, very complicated situation. Now, when it comes to a personal injury claim, what would be the result if the victim was the winner in the case? What could the business be ending up paying out?
Well, as I say, for the discrimination element, it's unlimited. For the personal injury, that compensation's calculated on the injury itself, the distress of the injury itself, how long that injury is going to cause that victim to be out of work in the future. Are there any special needs that she's going to need or he's going to need now that they're out of the job and they're at home? Anything really that can come in that's directly arising from the personal injury can be compensated for.
And you mentioned that Richard has to go through a long, unwieldy process to ensure that this lady in question is still in employment. How long could that take?
Years.
Years.
Quite frankly, it can, yes. I don't know in this case, quite what the situation is, but sometimes it can. The problem is that you have to go through a medical process at this point. The thing, you can't punish somebody for their illness or disability. It's not a punishable offence. You have to seek a GP report perhaps. Are they fit for work? Can they come back to work? If so, what can we do to make sure that employee is fine when they're at work and we're not putting too much stress on them? Do we need to make reasonable adjustments? And that can be anything from, if you've got somebody who's got a back problem, they might need a special chair at work, to you might have to do a whole change to the building if it's somebody who needs an actual location amendment to facilitate their return to work. So it is a long process. Sometimes the GPs don't really give you the information that you need, so you have to get a specialist report on it, and then you have to look at what can you do in the workplace, because it's a separate discrimination issue if you don't make reasonable adjustments for that person as well. So it's something that you've got to be very careful of, and you've really got to go through that process, because it's just undeniable that otherwise these days employees are clued up, they know what they're doing, and they can raise this.
And we hope that Richard will resolve this situation pretty soon, and he has to resolve it sooner or better before it becomes an even bigger problem. So hopefully, Richard, that's given you some pointers of where to go and how to go about it and what to consider. And that's our employment law questions for this week. Now, we're going to say goodbye to you, but it's going to be goodbye for a few weeks, because you're going to be back here on the 8th of June, aren't you? But not talking about employment law. No, we're going to be talking about my other little passion. Which is Take 3 Theatre. Just briefly tell us a bit about that for a wee minute or two.
Okay, well, all lawyers are actors, failed actors probably. So in 2006, we started up Take 3 Theatre School, which is there for young people between the ages of 6 and 18 to come and learn to sing, dance and act with us. We do examinations, the London Academy of Music and Dramatic Art exams. We've been to the Fringe, we've done all sorts of things. And we're going to be doing some performing for you as well at some stage.
I know, in the coming months here on Radio West Fife, so we're looking forward to that. So I think what we'll do is we'll find out a bit more about that on the 8th of June.
Okay.
So Jacqui, thank you very much for coming in and answering some of the employment law questions.
You're very welcome. It's been a pleasure. Thank you very much.